In the justice system, the people are represented by three separate but equally important groups: the judge, the defendant, and the plaintiff. These are their stories.
Okay, welcome everybody. This is our Law and Order Discovery Dispute Unit. We are on episode 6, the hard reset, Wiley versus LCS. And before we get started, I wanted to introduce our participants today. Our defendant is Jay Yelton. He's a partner at Warner, Norcross & Judd. He has spent 30 years as a litigator and a manager of e-discovery. He now focuses practice on mediation, where he helps his clients solve disputes quickly. And he is involved with the Association of E-Discovery Specialists. I think he's the president in Michigan. We also have Joe Rogan, who is from Smith, Holsey, and Busey. He is a shareholder over there. And he focuses his practice on resolution of complex business disputes and on creditors' rights. He is also very involved in the e-discovery community down in Jacksonville. And Jeff Hudson is going to be our judge today, and he is the Director of Professional Services here at Acorn Legal Solutions. He's an experienced complex litigation attorney, project manager, and technology leader. And he is going to be the judge. And so with that, I'm going to move on to a quick coverage of the facts of our case. If Luke, you want it, there we go. So our plaintiff, David Wiley, he's a former chief engineer at Lockhart Computing Systems, which is a national developer and producer of computer components. When he retired in March of 2015, he entered into a retirement agreement with LCM, and that provided he be paid a portion of his salary as long as he abided by a non-compete clause in that agreement for 3 years. The May of the following year, Wiley accepted a position as a consultant for Holmes Integrated Components. At that point, LCM said, we're going to withhold your retirement benefits because you violated the retirement agreement by accepting this consulting position. So the plaintiff has filed the present suit, and he's claiming that LCM violated the retirement agreement by withholding his benefits. And Wiley contends that the company he's now working for is not engaged in the business that's competitive or the same as LCM. He claims that HIC is a supplier to versus a competitor. And LCM says that HIC is engaged in the same business, which does in fact violate the non-compete clause and allows them to discontinue payment. During the course of discovery, Wiley submitted a repeated and broad range of search terms and custodian lists to identify documents that were potentially relevant to the litigation. LCM ran these terms across the data set, and the hit count was very low and not as robust as Wiley would have preferred. And so he requested that there be additional data from custodians and that LCM be compelled to use technology-assisted review, or TAR, as we'll be referring to it throughout the rest of this, across the data set so that they could more quickly identify the responsive documents. LCM says, based on the search term sampling we've conducted and some other stuff we've been doing, TAR is going to be disproportionate, it's going to be too expensive, and isn't likely to increase the responsiveness in the data set. So during the motion to compel the use of TAR, this court cautioned the plaintiff that if TAR did not improve the responsiveness rate, they would award costs to the defendant. And LCM did follow this TAR process as requested, and upon completion, the responsive rate of the documents in the data set did not improve. And that is where we are today. We are on a motion to shift costs. So with that, I'm going to turn it over to the defendant.
And Jay, this is your motion, so I will turn it over to you to hear your argument for why Joe and Mr. Wiley should pay for your cost associated with this TAR ambition.
Well, thank you and good afternoon, Your Honor. As you said, I'm Jay Yelton and I represent the defendant, Movement Lockhart Computing Systems. And we're here today requesting that this court shift the cost that my client, the defendant, has incurred complying with the plaintiff's discovery request, in particular, stage 3 of the discovery request, where they demanded that we utilize technology-assisted review, or TAR, to identify documents responsive to their discovery request. So we make this request pursuant to Federal Rule of Civil Procedure 26C1B, that states that the court may, for good cause, allocate shift discovery costs to the requesting party as a means to protect that party from undue burden or expense. When you hear the history of how the plaintiff has conducted their scattershot discovery over the last 15 months, it is clear that the plaintiff has imposed undue burden and expense on my client. An important factor in evaluating undue burden and expense is what was the purpose that the discovery was seeking. The plaintiff in this case, please recall, is a former employee of my client. In fact, he was there for 20 years and served in the role of chief engineer. Despite that fact, plaintiff requested broad and burdensome discovery to refute our client's claim that Lockhart's business overlapped with the business of his new employer, Holmes Integrated Components. Obviously, there's a lot of different ways one can approach discovery or seek discovery, in this case, to prove a business overlap between two companies. Plaintiff's own testimony as an employee of our company, as well as Holmes, is relevant. Documents from Holmes, his current employer, as far as business overlap. You get Rule 30b-6 depositions of Lockhart employees on this topic, or depositions of others in the industry, or you can get expert testimony. So there's lots of different ways to prove or to seek information regarding that point. But instead of doing that, those discovery options, the plaintiff pursued the scattershot effort to seek as many documents as they possibly can. And they did it by seeking a lot from custodians and search terms. In fact, they asked us to search 69 employees for relevant or responsive data. And in addition to that, all of their executive assistants for those 69 employees. Not only was that incredibly overbroad, they asked for over 90 broad search terms. So, in response to that, we negotiated this round one, negotiated with the other side, and we were able to narrow that down to some extent. And then we went through the whole effort, identifying, collecting, reviewing, and producing responsive data pursuant to their protocol. It was their strategy. And in the result, plaintiff was not satisfied. So plaintiff and defendant sat down again and negotiated a second round involving same thing, search terms, custodians, and again, defendant undertook that effort and turned over the responsive documents under that round two. And guess what? Plaintiff's not happy again. So then plaintiff comes back to us and says, hey, we want to do a third round. We want to start all over again. And this time we want to use TAR. And we said, well, enough is enough. We're not doing round three. So plaintiff's response to that was file motion to compel. And as you well know, it was for you, and at the hearing, you had questions about this. You warned them explicitly that if we go down this path and the potential negative implications of costs associated with going down this path, this issue is going to come up if in fact round three is no better than round two and round one. So, but Your Honor ordered us to go down round three, and we did. And my client has incurred over $550,000 in fees to complete round three. And as you suspected, the results are not better. In fact, they're significantly worse. The percentage of responsive documents for round two was 55%. Responsive documents for round three, 36%. So bottom line, in evaluating whether a party's discovery requests create undue burden or expense, most courts look at the proportionality factors that are set forth in Federal Court Rule 26b-1. And they include the following. One, importance of the issues at stake in the litigation. This does not involve some broad or important public policy concern. This is a breach of contract involving an executive's severance package. That's it. Amount in controversy. This case involves 2 years of that severance package over a 10-year, it was a 10-year agreement, and this involves less than 2 years of that package. Third factor, parties' resources. Plaintiff is very wealthy, A, and B, this case is being funded by the plaintiff's current and new employer. So The next one is the party's relative access to this information. Now, as I mentioned, he probably has the best access to this information. The issue is the overlap in business between the defendant and the plaintiff, the companies that he was at. And so not between the defendant or the plaintiff, but between his former and his current employers. He had access. I mean, he's been with us 20 years, so he knows our business, and he's at Holmes now, and he has access to their records. So if anyone has information about the overlap of these two businesses, he's in the best spot or position for the access to relevant information. And then the last one is the importance of the requested discovery. As I said, there's many ways that one can research or determine this issue of overlap. This was not the one. So the method they went, this discovery was not important, was not needed. So in summary, from day one, plaintiff has pursued a scattering of ESI strategies, and they failed. Plaintiff has been using discovery, frankly, for the purpose of imposing burden and expense on my client. So, Your Honor, we respectfully request that you shift all the fees, not for round one, not for round two, but for round three, onto the requesting party, the plaintiff. Thank you, Your Honor.
Thank you, Jay. Joe, your response?
Good afternoon, and may it please the court. I represent the plaintiff, David Wiley, who, as my colleague said, is the former chief engineer at LCM. I want to make 3 high-level points, then I'm going to spend some level of detail on point number 3. I'm going to talk a little bit about Rule 26, and then I'll conclude by asking that you deny LCM's motion without prejudice to refiling it at the conclusion of the case. So first, there's no doubt that the document collection in this case and the culling process failed. I don't want the court to think for a moment that we're happy about a 36% responsiveness rate. I have to review those same documents. 2, the science supports the merits of TAR over traditional keyword searching or the ways that the defendant proposed to litigate this case. We didn't ask for anything exceptional. My former boss, who presides in the District of Maryland, generally requires TAR absent agreement of the parties or some compelling cause otherwise. And then third, most importantly, to cost shifting, and this is the point I'll spend some time on, Mr. Wiley and I did not cause this problem by ourselves, and let me discuss that in a little more detail. The parties tried multiple rounds of sampling, as the court remembers, and they didn't work. We started at 55%. We came in and asked for 69 custodians and 803 search terms, and I understand that the defendant and the court didn't like that. And so we ended up with 7 custodians and only 3 per topic and only 25 search terms. And so when we compare our 36% responsiveness rate to the keyword searching, it's not comparing apples to apples. This process was deeply flawed from the beginning. In August, the court will remember, we tried this the defendant's way and ended up with only 173 responsive documents. We know that that can't be enough in light of what's going on in this case. At the end of the day, we started with 1.8 million documents and filtered those down to about 322,000 before we started TAR. That's pretty good filtering. That's a pretty sizable reduction in the document universe before we started our review. And LCM spent hundreds of thousands of dollars before the last hearing when they started raising issues about document collection and culling. In all of this process, when we're going through and we're trying to narrow down the culling, we're trying to get the TAR working right, we were coming up against a slew of depositions that the court may remember we discussed in the last hearing. And although we pushed for TAR, its results were not Mr. Wiley's sole doing. And the request for it was not anything abnormal in a complex case like this. So then I want to talk a little bit in my last couple minutes about Rule 26b1. I agree that the court should look at the proportionality requirements in that rule. And the default rule, as we all know, although my colleague didn't say it, is that the producing party bears their costs. And so the producing party, as the movement here, has the burden of asking the court to deviate from that. Under 26b1, I can combine importance of the issues, amount and controversy, and the cost-benefit analysis. Here, we're trying to figure out what business LCM does. And that's the sole reason that LCM thinks that they can take away millions of dollars of Mr. Wiley's retirement benefits. we shouldn't and need not take the defendant's word and cherry pick the 173 documents in testing LCM's allegations that the business of Mr. Wiley's new employer is the same as his old employer. We get to test those allegations, and before the defendant gets to take away my client's retirement benefits, we get to figure out if those businesses really are the same. My client, who, as my colleague said, is in the best position to know so, says that they are not the same. And so we talk about the parties' relative access. The defendants are the only ones that have these documents about the business that they say overlaps with my client's current employer. If they want to take Mr. Wiley's word for it, then this case would be over pretty quickly. He thinks that the parties do not share a business. So the defendant is necessarily going to share a heavier burden in discovery because they have the documents relevant to the critical issue here. And as far as resources go, Mr. Wiley is not poor. I don't think there's any evidence that he's wealthy, as my colleague said, but I don't want to come in and argue that he's here before the court asking for a waiver of costs. But yet there's no doubt that LCM has the resources to fund this defense. Remember, LCM is the party trying to avoid paying Mr. Wiley millions in retirement benefits and now comes to the court to complain about the costs to defend the action. So in close, we have a lot of work to do in discovery in this case. It's not over yet. We're getting there. We're narrowing down the field of documents. Although we're not happy about the responsiveness rate in TAR either, but we have work to do. And it's premature at this stage to stick Mr. Wiley with the bill before we see what all he's able to unearth and how that discovery impacts the merits. So I'm not going to ask the court today that you deny the motion entirely, but I ask that you deny it without prejudice so that we can figure this out once we get to the merits of the case. Thank you for your time.
I appreciate both of your arguments, and they are both well received. They are both well organized and very thoughtful. I believe that we do certainly have some question of fact that is not going to be determined by neither me or us. However, when it comes to the discovery issues that we have and the relationship of that discovery to the demand for TAR, I am willing to shift some of those costs, not all of them. I'm willing to shift some of the cost related to the cost of the technology assisted review to the demanding party. However, I am not willing to shift the attorney's fees to that party because I believe that those fees would have been incurred with or without the insistence for technology assisted review, because I believe that the document requests in this situation were broad enough and significant enough that it would have taken significant attorney time to review those documents. So I will not shift those costs to Mr. Wiley. So I thank you both for your arguments. I thank you both for your time. And with that, we are adjourned.
Do you want to switch to the other side? I know Jay, did you have something you wanted to add? I saw you come off mute.
No. I just came off mute because I thought we were going to kind of talk.
Perfect.
So
we
I
are.
was already told I had no rebuttal and I had no ability to appeal. So I'm very accepting.
And so some of the, obviously this was based on a case that actually came out last year, the June 18th, 2020 decision, Lawson versus Spirit. There, as you can see, there have been some subsequent decisions about this case that have come out since the June decision. But essentially, real quick, the facts of that case were very similar to ours. There was a CEO who had left and gone to consult for another company. He had a part of his retirement was going to be paid out if he didn't compete. Similar questions about the business. And the court repeatedly admonished this plaintiff to not continue down this discovery path that he was going down. And if he did, he was going to be, award costs back to him. So, and he did. And essentially the court awarded these costs they shifted costs from the defendant to the plaintiff. Similar, a little bit different from our decision, but it was a big case that came out last year. And then the subsequent cases were around the same ideas, basically awarding more money. I know one of them has a really good breakdown of awarding fees. So the judge kind of lays out every single line item fee and why he's awarding it and why he's not, what he would reduce. So if you guys are interested in these cases, definitely let us know. We can send you links. They're interestingly reasoned, and the judge lays out her thought process pretty clearly. So
we also adjusted the percentages in our case to make it a little bit more fair for Joe and Jay. The actual case was more along the lines of 4 or 5 to 8% responsive, as opposed to somewhere in the 30 to 50% range. And
so it's definitely an interesting case. We don't often see the costs get awarded to plaintiffs, or, the cost shifting back to plaintiffs. I know Doug has made a comment sort of pointing to that point. I thought they were very interesting cases. I don't know, Jay or Joe, if, what your thoughts are on this case. I know it's been really common in the sort of in the e-discovery world. Everybody's talking about it. So
I think it's really a fascinating case, and it's an example of why you need to do your work on the front end. I don't know whether everybody can see these or me, but I see a question that was submitted by an attendee about the application of the Sedona principles and being able to essentially throw this back at the producing party to figure it out. And in a vacuum, that's absolutely what should have happened in a case like this. By the time it got to this stage, we're at the 5th hearing and we're so far in that it's difficult to just punt it back to the producing party. But it's very rare that you see these. The argument I made today, for me, strikes me as being the most interesting is the timing of when these were awarded. And so, you're going to tack the plaintiff with hundreds of thousands of dollars of costs when it's possible that they found the document they needed to prove the case or to disprove the case. But if you go read the actual opinion, I think it's 46 or 50 pages long. It's fairly persuasive, and so I was happy that Amanda and Luke made the facts a little bit better for me, even though it was still a tough argument on my side.
Yeah, I think that one of the main issues here was that the document set just wasn't very persuasive for the plaintiff. They just didn't have the evidence that they needed to make their argument necessarily. So regardless of what methodology that they used, whether it be more traditional methods like search terms, or whether it be more current methodology like TAR, they just didn't have the data to back the arguments that they were trying to make. And that's why you get somewhere between 5 and 8% responsiveness, is because you don't have the data to back your claim.
Yeah, what I found really interesting, and Joe mentioned how long this particular opinion was. It would be wonderful to read all the prior opinions, but I got to tell you, I don't know if I have the mental capability to do that. It's amazing it got to this point of a train wreck. You know what I mean? And that's and what I mean by that is that, and I don't know whether my first argument made any. It was not in the opinion. They made no reference to. I just find the whole thing that they're doing search terms, that the emails and documents at my company are going to be really important evidence of this, whether 2 companies are in the same business. You know what I mean? So early on, I would have been trying to fight. We don't need email discovery. We don't need, maybe a couple custodians. And narrow the search terms. I know they did some of that narrowing, but I assume the plaintiff has been or the defendant's been fighting against this from the beginning. And that, one of the always things I think is important, is there other ways to prove the same point? You know, I mean, before we go into all these rounds of discovery. So maybe they made those arguments early on. I don't know. And that was, I guess, one of my points in response to that question as well that was put up there. I think that point is an excellent point. And I would hope that that was part of the prior motion to compel, you know what I mean, as far as trying to avoid even having to use the TAR. But yeah, Joe was in a very tough spot. I thought he did, you know, real well. I mean, he focused on the default rule, you know, and he's right. I didn't mention that. You know, generally the rule is that that I'm going to incur the cost. And I thought he did a nice job of comparing the 550,000 to the millions that my client is saving, you know what I mean, because we terminated them, you know what I mean? So, I mean, when I first read our facts in this case, you know, yeah, they struck me strange, and I kept wondering how much is involved, you know what I mean, to get to this level. Then when you read the real case and you realize, I mean, this guy, this plaintiff is a mover and shaker. I mean, his job for this, I mean, it was tens of millions of dollars as this advisor for the second company. So yeah, we have him as a chief engineer, by the way. He was a CEO of the prior company. So, you know, that's another piece of it as well, which again, I mean, as a CEO, why do you need people's, and maybe I just don't understand this element of a case as well as I should, is why do you need all this data from the prior company to prove that point? I mean, that still surprises me, and I don't have an answer for it, but.
Yeah, I think that's a great point. And the fun fact in the case we based it on was that the CEO was actually indemnified by the new company. So it was his new company that was paying for the entire lawsuit. So maybe that drove some of the decision making if it wasn't his dime. It's a little bit my perspective, but yeah, I think that it's definitely an interesting case. Anybody in the audience, if you haven't read it, it's definitely well worth taking the time. It's a little long, I'm not going to lie, but it's definitely an interesting and a really good outline of the proportionality standard. I like how the judge lays out, here's all the different pieces that I've put down, you know, for each step of proportionality.
Leah asked a question, and it's a good one. And I read most of this opinion. I can't tell you I read every single piece of it. I did not see any reference in the opinion where there was coordination and discussion between the parties on how the TAR process is playing out. And Leah raises that question about, because, you know, they demanded it. You would think there should be communication back and forth between the two parties throughout the process, hopefully to narrow things down. I don't know if that happened. I mean, there was no reference to it. But as Leah had mentioned, I think that's an interesting omission from this case. Is why wasn't there this communication back and forth throughout the process? And maybe again, we just, you know, some of these cases, and when you have not a terminated, but a former CEO, and you know we got this much involved, maybe got so personal that there was just not those type of communications that should be happening.
I think this is a case where, and I really don't recommend this as often as some of my colleagues that participate often in e-discovery world. This is one where the parties would have benefited from a really good special master, somebody like Grossman, somebody who really understands the tech side and the legal side. And if you had gotten somebody like that involved at the early end of this case, you would have done smaller and better sampling so that you could have seen that you were going to come out with, in the real case, like less than 5% responsiveness before you spend $500,000 to get there. And so it's about taking smaller size bites. And if the parties and counsel can't communicate with each other effectively, really counsel can't communicate effectively, then you've got to get a neutral who can. But it doesn't serve anybody's interests on either side. Putting aside the indemnity that the plaintiff had from his new employer, it doesn't benefit anybody to have spent $2 million in discovery to review 1 million documents and have less than 5% of them responsive.
I agree 100% on that. In fact, that's kind of turning my passion for the remainder of my career toward that. And Special Master and Mara is awesome. And there have been programs like you suggest over the last 5 to 10 years. Interestingly, they have not got as much traction as one might think. So one of the things we're trying to explore is discovery mediation. I mean, because a special master, it seems like courts are a little bit hesitant to appoint a special master to make decisions that especially in federal court, that a magistrate would want to do. But a mediation, you know, essentially a forced meet and confer with a neutral. You know what I mean? I mean, people got to blow through the meet and confer right now, you know, shooting emails back and forth and not really trying to work things out. So I cannot agree more that hopefully over time we'll see more efforts, whether it's special master, discovery mediator, discovery facilitator, something, forcing people to talk early on and doing staging and sampling so we don't have cases like this and we don't have to read these long opinions in the future.
I think that coordination could have eliminated almost all of this. If the parties had gotten together and actually discussed what they were looking for and what they were trying to achieve, instead of using discovery as a sword instead of a shield, they could have gotten through a lot of it.
And it looks like we've come up on our time. So if anybody has any questions, if you want to send them in now, I would like to take this opportunity to thank Jay and Joe for their really awesome and spirited debate. I appreciated the insights that they brought to this case, and to Jeff as well.